Good afternoon, and it's September the 5th, 2023, and we're talking again about international private investment funds that are set up by owner managers, family businesses in Latin America and Africa and other countries for projects outside of the U.S. and the USA. These regulated alternative investment funds, they're also called, are used to raise capital from U.S. accredited investors. And these types of international private investment funds are often less than $100 million, and therefore they don't attract the interest or the participation of large institutional and regulated private equity funds, banks, and all the other big kind of institutions that are out there. So today we're going to just talk a little bit about the fiduciary obligations of fund managers and investor protection. And so for an international private investment fund that has a project or a business outside of the continental U.S., the U.S. jurisdiction, U.S. investors are generally quite conservative when it comes to international private investments, as are their advisors and as are their private banks. Remember, when you get investment from a U.S. accredited investor, quite often you have to get the funds from their trust or from their bank. And if they have a trust structure, which many wealthy accredited investors do, the bank's compliance department will view an investment into international private investment fund as a highly risky venture, and also they will see it as presenting high compliance risk and a high potential for fraud. And so these are things that international private investment funds run by owner managers have to work to overcome. And there are many things that can be done to mitigate these concerns. We've talked about a few of them in other videos, but now we're going to talk about something more to do with the investor protection. And quite typically, until recently in the U.S., lawyers, of course, who are often heavily involved in setting up funds of all types and sizes, will reduce or exclude what's called the fiduciary obligation that fund managers have to investors. And so let's consider all these funds, these domestic private equity funds in the U.S., small and large, regulated and unregulated. Often lawyers will have clauses in the limited partnership agreements and other agreements that would remove fiduciary obligations. So why are they doing this? Now, it is important to know that for people, owner managers and families from civil law jurisdictions where you are, say for instance, in Brazil and Peru and Colombia, where if you're from a civil law jurisdiction, so people from civil law jurisdictions, many African nations are also civil law countries. You're not common law countries, so the big thing we're talking about here is the law of equity. Civil law countries don't have the law of equity, which is one of the things it includes is the law of trusts is based upon the law of equity. But trusts are not the only thing, the only mechanism coming out of the law of equity. In the United States, what I find is that many people that come from civil law countries don't realize is that the most powerful protection you can have in the U.S. for property rights is contained within the law of equity. And so U.S. lawyers know this, and protecting their clients who are service providers, they will obviously, with good reason, seek to remove and carve out fiduciary obligations to investors. So that means investors who are investing in funds where the fiduciary obligations are removed have less protection. There is more scope for an investment fund manager to carry out fraud or do things that are not in the best interests of the investor. And so the better situation, of course, is if there are fiduciary obligations, they're not restricted or removed, and therefore the fund manager does always have to act in the best interests of the investor. And so recently, I think last week or the week before, the SEC has issued some new rules for funds all across the United States. And while they did not address very well what they call foreign private advisors or foreign private fund managers, private investment fund managers, or while they didn't really focus very much on the international perspective, they have essentially mandated that fiduciary obligations can no longer be removed or restricted as the way they were previously in a lot of limited partnership or other fund manager agreements. And this is good news for investors because it gives them more investor protection. It's the fund managers will say it's bad news for them because now there's a lot more compliance, a lot more legal risk. Their costs are going to go up, and so there's a balance to be looked at there. But for international private investment funds, you should always anyway have been offering to U.S. investors, because the business of the fund is outside of the U.S. jurisdiction. You should have been offering, including fiduciary obligations in your general partnership company. And this is a consideration where your GP should be located in your general partnership should be located in a common law jurisdiction, so that the law does apply, the common law does apply, the law of equity. And this is what you should have been doing anyway. Now it's going to be required by the new rules. And so a GP outside of the US that's hired a regulated fund manager, and then you're going to have an entity in the US, which we explained the reason for the US presence in another video, that the agreement between the fund manager of the fund and US investors should contain fiduciary obligations. Because U.S. investors are way more conservative and biased against international private investment funds than they are U.S. domestic projects. So to be able to attract U.S. investors, you need to have those fiduciary obligations in there so that potential U.S. investors and their advisors in particular can see that you have offered them a significant amount of investor protection. By no means is this the only thing that will convince a potential U.S. investor, but it is certainly a very important part of the puzzle. So make sure and do remember that when you're dealing with your the U.S. aspects of your international private investment fund, that setting up or including fiduciary obligations is of tantamount importance to U.S. investors. In another video, we will talk about, say for instance, instead of a legal entity like an LLC or a corporation, you could use a U.S. revocable trust as the vehicle which is going to issue units to potential U.S. investors. And a U.S. revocable trust, which is would be controlled by trustees in the U.S. and trustees in the U.S. Yes. It will basically, a U.S. domestic revocable trust is a flow-through, or what they call a grantor trust, is a flow-through entity, and therefore it, from a tax compliance point of view, is a relatively straightforward and simple way for U.S. investors to invest into the International Private Investment Fund. But the most important point is that a U.S. revocable trust is a creature of the law of equity, and it is, has law of equity, and the fiduciary obligations are part of trust's very nature. And so therefore this mechanism would definitely have access to the law of equity in the U.S. court jurisdiction. So this is a very powerful way of offering significant investor protection to U.S. Potential investors, and something that the non-U.S. owner-manager should consider. In other videos, we'll get into some of the implications of how to use revocable trust with U.S. investors and an international private investment fund that is raising money for a project which is outside of the U.S. jurisdiction. Okay, thanks. Cheers.